everyone, welcome to the Communication and Conflict YouTube channel and Chaos podcast, promoting mindful communication and growth through conflict. So today's video is going to be a Mediators Discuss video and podcast on chaos. And I'm very much looking forward to having a discussion today with Melloney Guiver, who is a HR consultant and employment law advisor, but also I'm very much aware is a trained mediator and conflict coach. And so we're going to be discussing today the topic of conflict resolution in workplaces and to draw upon our kind of respective experiences of that topic. So Mel, what would you like to say to introduce yourself?
So, hello everybody. So, as Alan said, I'm an HR consultant in employment law, and I'm also a solicitor. I've been qualified for 17 years. And I was thinking about how long ago it was that I trained Alan as a mediator and conflict coach with you, and I think it must have been about 2014 or so. Mm-hmm. And I also had trained with another mediation organisation, but came to you because I didn't feel it kind of fit with how I saw mediation really operating. So yeah, that's me, and that's what I do day to day, mostly advising on employment problems and conflict. That's mostly what I do. Mm-hmm. So yeah. Alan, tell me about you.
Yeah, okay. Oh, okay. Yeah. So I'm a mediator, trainer, conflict coach, and I've been doing that for the last, I always have to calculate it, was 94, so it's 27 years. And I've worked in various areas of mediation during that time, but particularly during the last probably 14 years, my focus has been mainly on workplace kinds of disputes, but in the past I've worked in various areas of mediation, neighbour disputes, community difficulties, complaints work, etc. But I won't go into too much detail of that now because we will continue into our discussion. So our topic, as I said previously, is conflict resolution in workplaces. So on that topic, Mel, what kinds of things would you want to look at today for us to kind of explore?
So one area that I would like to talk about is disciplinary and grievance procedures, and I have a view that they don't resolve conflict. They're just purely a way of managing it, and really looking at what might alternatives be to using those procedures to actually truly support employers and employees to resolve conflict in the workplace. Yeah, and really considering how mediation is one option, but also communication, really interested in how people communicate with one another and how alternative ways of communicating, or perhaps ways that we're perhaps not used to communicating, could support resolution of conflict, and that perhaps if there was more training for both employers and employees on communication and how to communicate with one another in a way that seeks to resolve conflict, we might not even need to look at disciplinary and grievance procedures at all, or at least less often.
Yeah. Any other things?
No, I think there's a lot there just in that for me.
Okay, so you said you'd like to look at disciplinary and grievance procedures that you think their purpose isn't to resolve but to manage conflict, and you think that alternatives to support and to enable people to try to resolve things could be considered and looked at. How mediation and communication training could help with that.
Mm-hmm.
And to look at alternatives, as you say, in terms of looking at training for people in their communication has a focus on looking at resolution rather than, as you previously said, disciplinary and grievance procedures not being about resolution but simply management of the situation.
Yeah.
How was that? I kind of felt there were some things I missed within that. What were your thoughts? Or is that pretty much?
No, you covered it. Yeah, absolutely. And specifically the alternatives to the alternatives to resorting to those procedures and looking at those procedures is mediation is an option, and actually conflict coaching is another option. So it'd be good to talk about those as options.
Yeah, cool. Okay. Yeah, so for me, the thing that I think I'm particularly interested in exploring is, in a sense, your side of things. Just the very fact of what you just said is interesting to me because, I've only ever been an external mediator. I've not worked within an HR department. I've not worked within the equality and diversity sections of organisations that perhaps, are the kinds of places that, in my experience, have referred cases for mediation when they've drawn me in. So I'm always interested to know what the factors are that come into play when an organisation might even consider mediation, and what the factors might be that mean that they don't use mediation. Obviously there will be, sorry about that, there will obviously be a range of different reasons in different organizations, but just in a sense to hear what your experience of that is. And I think in many ways, as I think already, I've got an interest in bullying and harassment policies. And for me, possibly, you will obviously tell me otherwise, but possibly some of the factors that come into the ineffectiveness of those policies are similar to the reasons that there's ineffective grievance procedures as well. So really just to explore that, I think, would be of interest to me.
So just to clarify, so from your perspective, you'd like to kind of hear things from my side of things. You've worked as an external mediator, so you've not had the opportunity or the experience of working directly in a business, and it's, especially when it comes to inequality and diversity issues. So I'd like to kind of look at the factors of why an organisation may use mediation, and what might mean they may choose not to, as well as your specific interest, I know, in terms of bullying and harassment, and your views in terms of that being that process or those procedures being ineffective for resolving those kind of matters, and you kind of liken those to potentially being the same kind of reasons for ineffectiveness as a grievance procedure. So
yeah, and even as you say that, I've kind of started thinking what for me seems to be the reasons, but it would be interesting to explore that. So yeah. Okay, so what would we say are the kind of main headlines or highlights of what we want to look at?
I think, I don't know whether we need to explain. I think I'd maybe like to just chat through kind of what the disciplinary grievance procedures are, just very briefly. And what their impact is or can be. So what their impact can be on conflict resolution, and why I don't think they work.
Okay, so impact of disciplinary and grievance procedures. For me, ditto for bullying and harassment. Any other things? I think this is a main
headline. So I think coming from what you said, the factors that come into play that might mean an organisation will consider it, and the same for an individual, that they may well be willing to consider it. And why perhaps it might not be considered appropriate.
Yeah. And individuals. Okay. Anything else? Because that covers it for me as well. But anything else you would like to?
No, that's it. That's it for me.
Okay. Disciplinary and grievance procedures and their impact. Ditto for me for bullying and harassment, although obviously as well as disciplinary and grievance procedures. And the factors regarding consideration for both organisations and individuals about whether they would consider mediation and conflict coaching.
Yeah. Yes. Yeah, absolutely. Yeah.
Okay. So where should we start?
I'll start.
Okay. That's cool. That's cool.
I'm really passionate about, so I've advised many businesses and many individuals about how to conduct a disciplinary and how to manage a grievance procedure. And I really dislike it in terms of the process, the procedure and the outcome that usually results from it. And that's often because I see them as being, they are progressive procedures. The aim often is said to be to resolve conflict or to resolve a dispute. But it isn't, because it's a process where the end result is potentially the termination of someone's employment. So with a disciplinary, with an absence management procedure, with a performance management procedure, they have a warning process through them, which ultimately, if the employee behaves or gets in line or stops doing what they're doing or isn't absent anymore, then they'll get to stay in their job. Whereas, and with a grievance, okay, it's not necessarily that somebody's going to lose their job, but it can result in the disciplinary procedure being initiated and somebody ultimately losing their job. That's not to say I don't see there being a place for disciplinary and grievance procedures. I think I see more of a place potentially for disciplinary when it's a very, very serious matter, when it's akin to something potentially criminal. Then yes, I think there may well be a place for it, and maybe it'd be good to maybe explore that a bit further with you and what your thoughts are. But with resolving conflict is there every day at work, and we can't avoid it, no matter how we feel about it. And so using those procedures as a way to resolve it, in my view, in my experience, it doesn't do that. I don't know of any. I do know of employers who go, yes, we've got rid of them. And I think, well, okay, maybe that is a success then. But then you've also got, we really didn't want it to end up this way. And for an individual, it's a really stressful and I think quite a degrading process to put somebody through.
I mean, there's so many things in what you've said which are, to me, are analogous to what situation with bullying and harassment policies are as well. Because while, in a sense, I would, from what you said and from what I've understood of grievance, disciplinary and grievance procedures, they are, as you say, kind of much more managed on a progressive basis. The eventual outcome of a bullying and harassment policy being applied is almost always exactly the same, that the one or both people involved, or more than one, if it's more than one of both people, leaves the organisation. And what doesn't happen, when you said about sometimes, rarely perhaps, but sometimes employers go, yes, we've got rid of them. What that's not acknowledging is, what is it that meant that person's way of being wasn't able to be dealt with within the workspace, and what therefore means, what now means that a similar person coming in won't experience and cause the same issues. So there's not been any learning from it. There's not been any development. There's not been any growth. And in both policies, there's always a separation of people. There's never a bringing together. So therefore, there's never, well, not never, I can't know it's never, but it's very rarely the case. It's almost always a standard procedure that if there's a bullying allegation, actions are taken to keep the parties apart. And from that point onwards, it's almost taken out of their hands. And for me, this is where for a lot of organizations where their difficulties come in, because what they do usually ends up being effectively kind of a claim of constructive dismissal. Yeah. So if you've got two people who have fallen out, then, you know, if it's a manager and an employee, but it doesn't have to be this, it can be two colleagues. One is, say, a manager, it may not be the manager, but sometimes it's both the manager and the person who's making the claim of bullying, move to separate roles. But even where it's just one that's moved, that person is almost inevitably moved to a role which is less demanding of them. So therefore, they're no longer doing the job that they're employed to do. And while a lot of people think that what happens at an employment tribunal is dealing with bullying, it's never dealing with bullying, because it's not a legal issue. It's always dealing with the way that the employer has managed the situation. And that will often be constructive dismissal. So absolutely. It's the employer's process which leads to the legal process following from it, the employment tribunal. And so I'm speaking there about bullying and harassment, but as you say, in both processes, there's an inevitable leaving, a kind of a divergence from the organisation, isn't there? And that means eventually that one or both people ends up leaving. And that cannot be good for the organisation, can it? Because the cost of that, just the cost of that in itself, whether there's a legal process or not, but the cost of employing someone, training them, losing them, having to re-recruit to that post is going to be multiples of the cost of something like mediation. And even if they were to try mediation and it were not to work on some occasions, you know, if we just took a random estimate figure that without even considering the legal costs of something, that it would cost them £5,000, say, let's just take a silly kind of estimate, say £5,000, just because someone is going through that process, the time taken, and that person then leaving and then having to be recruitment, it's going to be more than £5,000, isn't it? But
it's going to be an awful lot more.
Say a mediation costs kind of 1,250. In a rough figure, 1,250. You'd have to fail in the mediation, would have to be to not lead to resolution on 4 occasions. Just taking those numbers, 4 times 1,200 on 4, it would have to not be successful on 4 occasions out of 4. It would have to be, sorry, I'm getting lost in my numbers, but I mean, it wouldn't have to be a successful 100% of the time is what I mean. But it's still to be massively a cost-saving process.
So you're saying that there would have to be 4, almost like the 4 touch points, the 4 occasions when, so the word you used, sorry, was occasions. So the mediation would have to fail almost on 4 occasions. So with that, are you talking about in the first place, the individuals are asked whether or not they want to consider mediation, they agree, there is meetings with both? Is that what you're thinking about?
Sorry, I think
you're thinking about something else?
Sorry, I was doing a kind of a cost benefit, a kind of cost risk comparison. So I think I can state it more clearly. It's kind of, it's as I say, if you said the cost of the person just leaving without ever looking at the massively greater cost of a legal process beyond them leaving, if you said the cost of a mediation was 1,250, and if you said the cost of them just leaving without any legal process beyond is 5,000, if that happened on 4 occasions, there would be how am I going to explain? It would be, I guess what I mean is you wouldn't even need to have 2 out of 4 mediations to be
cover
successful,
your costs,
for it still to be a better option. It would still be a cheaper option to try mediation. So sorry, it's a really bad kind of way of trying to voice it. I'd need to kind of rephrase what I mean. But as I say, if you try mediation, it doesn't work, okay, you still got to go on with the rest of those procedures. If you try mediation and it does work, you're saving a massive amount of money. So taking the risk of trying mediation is entirely reasonable on a cost risk analysis basis, is what I mean. I've just explained the actual numbers badly, but just that cost of mediation, the risk, you know, it would have to fail on so many occasions to be a useful process for it still to, for it not to be worth considering that cost outlay to try it. And yet in so many cases it doesn't happen. And some people might say, yeah, but the participants don't want to try it. And I mean, then we need to go into looking at, well, how are you offering mediation? That's the thing, because so often it's offered once and it's assumed that if they don't want it at that time, then it's never going to happen again. Whereas, as we've discussed before, it's if mediation is always available throughout the life of a dispute, then the chances are far greater that people will take it up at some point in that journey. I mean, it's not quite on our topic, but that's one of the things that is so often a reason why mediation isn't used as often as it could be, is that it's just put in at one place in the journey, and people say, oh, you should always try mediation early. There's no reason why it should have to be early. It should be at any point in the journey of that dispute, because I mean, I've provided mediation in a lot of situations where people have reached the grievance procedure and beyond, and they want to try mediation because they realize how it's just not working for them. But in a lot of processes, and in a lot of organizations, it will be deemed that because it's reached the grievance procedure stage, well, mediation is not going to be offered or used or useful. But there's no logic to that, because it can always be used at any point in the life of the dispute. Sorry.
Absolutely. I'm going to confirm really my agreement with you on that, which is that I think now ACAS, because ACAS have an awful lot of resources on their website, including a disciplinary, a sample template disciplinary code. That was not a sample code. They have a sample disciplinary procedure, and there's a code of practice. And within that, there is now reference to mediation. I think it's still, as you said, thought of as something that you would look at before trying, or you try it. It's almost like a try it first, and if this doesn't work, we'll go down the formal process. Whereas I agree with you that actually having that paragraph about mediation, having it in there is, in the first place, great, that at least it's acknowledged. But also, and in terms of grievance procedures, but actually it should be more than that. It could be, it's an option for any point in time. And especially where individuals, whoever is involved in the conflict, if they come to the conclusion that that process is not going to work to resolve it, because my experience is, as I said earlier, is that it rarely resolves a conflict. It is a way of managing it. It is a way of, it ticks boxes as to, we have a meeting, we've discussed it, but there's so much more about the way that it's managed that I kind of disagree with, really, in terms of it. You're going to have a third. In both disciplinary and grievance, you've effectively got an individual assigned as a disciplinary officer or a grievance officer, and the very language that is used in those procedures is akin to court language. We talk about evidence, we talk about allegations, we talk about whether it's proven or not. And I'm not suggesting for 1 minute that a business isn't and should not follow the law. That is the law. That is what it is at the moment. My hope ultimately is perhaps, there could be a change to that, or that at least mediation and conflict coaching could be something that is not just tried a bit like before, but is actually something that isn't just an alternative, but actually that the principles could be applied to those procedures. What's really important to me is that disciplinary and grievance procedures, as well as being almost like akin to a court process, which most people are not used to that. It is not normal. An employment is a relationship. It is a relationship between individuals. Yes, there's a business, but the business is the people who run it. And you rarely start a relationship and saying, well, where things go wrong, well, we're going to run it like a court process. Well, most relationships, when they go wrong, involve a chat about what's gone wrong and an attempt to put it right. Exactly. Now, of course, if the relationship is broken or one party doesn't want to carry on with it, then you're better off getting to the crux of that and deciding how you're going to both move on. Whereas using this procedure almost as a sham, which can happen, or expecting it to resolve it, is it's also it is parent-child as well. So, the fact that it's disciplinary procedures, sanctions, at school, my daughter, if she doesn't do her homework, if she forgets a pencil, a pen or whatever, she gets a sanction. She hates it immensely. And I think most children do. And we've carried that into employment. We have these penalties. So, Mel, if you're late for work 3 times, we'll chat with you about it. And if you keep being late, we're going to give you this warning. Well, actually, Mel, there must be a reason why Mel's late quite often. And why is Mel late quite often? And let's get to the bottom of that. To resolve it. Because issuing me with a warning isn't necessarily going to stop me being late.
And it doesn't try to find out the reasons why, as you say, does it?
It doesn't. And the process should, in reality, the way the process should run should give the employee the opportunity to say why and what's going on. But the very language and the very way that the processes are often held, formal meetings, you've got the right to be accompanied. It is almost like, and as I said, the language and the court process, how is anybody going to be comfortable just chatting about it? And of course, hopefully most employers and employees do have those conversations before you get to the formal process. And most businesses probably do that, but it's still there in the background. And it's the very language that's used in the first place. It's alleged, I've drafted these letters, and I'm now trying to find a way to change my language and encourage my clients to walk with me in that process to change that language, for it to be not an allegation, not don't go down this disciplinary route. There's something that's not right here, and can we have a chat about it and try and sort it through? And then if we need to go down somewhere formal, okay. But actually, there's mediation, and there's there's mediation mediation can be used from a disciplinary perspective, rather than it being, I'm the employer, you've done something wrong.
I think obviously there's so many things come up in terms of what we both kind of understand and kind of see about conflict resolution, is that it being an adversarial process, however much people may say, oh no, but we're nice to them when we do it, it's like, well, the point of it, it's an adversarial process. It's a proof or not proof process. It's past focused, it's not future focused, so it's very much a blame approach. So therefore it's always looking at the past and finding evidence for the past in saying something's clearly not right here, how can it be better in the future? So therefore the non-adversarial process and mediation being about trying to create something better and different for the future. And as you said earlier, if it really is a serious thing, then any employer is duty bound anyway to look into it. But when it's a relationship breakdown, when it's about, as you say, someone turning up late or perhaps not managing to quite fulfill their job as well as might be hoped, okay, there might be a requirement that those things be put in place, but there can also be a future focused look at what's the difficulty here? How can this be done differently? And that doesn't even need for there to be mediation or conflict coaching. It needs there to be managers, and for me that comes back to what you were saying earlier about training in communication skills, because those, you know, the skills that, say, mediators and conflict coaches use to help people to create answers for themselves that support them in doing so, are skills which, even if not through a formal process like mediation or conflict coaching, managers can learn to develop to understand why things might be said in a certain way. You know, what would help you here? Why is this being a problem? What might you be able to do to change this? What support might we be able to provide for you? But at the end of the day, it's your job to make this improvement. We're not going to do it for you, but we can try to help you with it. As opposed to, if you do it again, you're going to get punished. If you do this again, without any exploration of what the context is, what the personal challenges are for that person. And those kinds of more creative conversations are the kinds of things that lead to identification of training needs and recognition of circumstances the person might have that might mean they need to move to a different timetable of working or whatever. But if all that happens, as you say, is they're put onto a disciplinary and grievance procedure, none of that gets looked at, and it's almost never going to actually resolve the problem because it's not looking at what underlies it, is it? So and ditto for me, again, transferring across the bullying and harassment policies, which I would very much, you know, see as similar in their ethos.
Yeah, I think what I like about what you said, or what's struck me about what you said, is the difference really in terms of, I think when there are practical issues where there can be change that is not about relationships, it's not about behaviour in the sense of, when you've got allegations of bullying and harassment, or when there are fallouts, often it's difficult to, being somebody who's talked to individuals who say, I'm being bullied, often it's difficult to get from an individual exactly what it is that is really upsetting them, and to really, because it's, well, they're bullying me, well, okay, well, what is the behavior, what is it that they're doing, and it can be very difficult to explain, because as human beings we use verbal, non-verbal, we use our intuition, and you know, there's what's going on up front, but there's what's going on around, and when there's fallouts, you know, there isn't really a process within organisations to sort it out, apart from using this adversarial grievance process, which, as we've said before, it's akin to a court process. It's somebody else making a decision about. So I feel that, you know, my manager is ignoring me. They want me to leave. They don't include me in things, and it's very difficult with a grievance process. The decision maker, who's another person usually in the business, is going to be saying, well, the evidence is, I can't see any evidence that supports that you believe that they don't want you in the business. But I still feel that. So you can have the outcome of the grievance is, well, my grievance, and I've drafted these, I've done grievances, and there isn't sufficient evidence to prove or to support what you're saying. So then, as the individual, it's, well, but I feel that. I still feel it. So are you telling me my feelings are wrong? Well, who am I to say that somebody's feelings are wrong? What their experience is what their experience is, and it does not. The process, the grievance process, isn't aimed to deal with that.
No, exactly. That's for me. That's to me. That's so I'm starting to kind of talk about the idea that bullying and harassment policies, they over-promise on bullying and they under-deliver on harassment, because and what you've just described is exactly what I've said. I did an article a while ago for an online HR magazine, and it was about the idea that bullying is an illusion, and as it can feel, because it's like a ghost. It's like you might see a ghost, think you've seen a ghost, but you tell everyone, but no one believes you.
Yeah.
Because how can you
That's a
prove
good
it?
way of putting it.
Yeah, and that to me is exactly like that. And people say, but I saw it. I saw the ghost. And they say, yeah, but you haven't got any evidence. And it's exactly the same for bullying. And so for me, that's why the idea that a bullying and harassment policy or a grievance procedure is going to solve that for anyone, it's a delusion. It simply cannot answer that question. I've never, ever come across any bullying investigation anywhere that has come to a conclusive outcome, anywhere. And what tends to happen is it just kind of, everybody gets kind of tarred with it. So the person accused remains with this kind of cloud over them, or, you know, they were accused of bullying, but were they proven? No, but, you know, someone accused them. And the person who feels bullied feels completely unlistened to and let down. And yet the policy and the procedure is never, ever going to work for them. And yet it's still the same approach that organisations across the world use. And it's all what you've described is also why I think it's really important to separate bullying from harassment, because harassment is much more clearly evidenced. You know, if I come in the room and say, oh, typical woman, not, you know, on the phone all the time, you know, blah, 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 and something like that, I'm immediately being discriminatory, you know, and anybody who hears it, no matter whether they think I'm joking or not, or even if you think I'm joking, it's discriminatory language. It's easy to evidence. Therefore, when we try to mix together bullying and harassment policies, it's like treating harassment as if it's like bullying, and it's trying to give bullying the status of harassment. And in neither way does it work. So, you know, if I were to use that kind of language, I would deservedly be strongly dealt with. And therefore, people who experience harassment in the workplace will feel supported because it's easily distinguishable. Bullying, on the other hand, is subjective, and it's never going to be supported by an adversarial investigatory process. So that's, to me, is why I think there needs to be a clear cutting off of the idea of a bullying and harassment policy, because they're completely different in terms of whether they can be evidenced or not. And they're completely different in terms of their status. Harassment is illegal and needs to be dealt with that way. And I would say that's why so many people who experience harassment don't feel that they're taken seriously, because it's you know, I'm kind of looking at policies at the moment of a lot of public sector organisations, and as you go through them, there wouldn't be any way in which a harassment claim would be treated differently to a bullying claim.
No, they're always put together. The
they're
terms
all put together, yeah.
All,
it's almost
the
like
terms
one
are
word, isn't it? It's
yeah,
like,
they are one word. It's bullying. Can't say bullying without saying harassment.
Yeah,
and you
exactly.
wouldn't say, you would possibly say harassment without the bullying, but most allegations, probably not most, how can I put it? So in my experience, the words are used interchangeably.
Exactly.
But they're labels.
Yeah.
And actually the tricky part is actually really helping or supporting an individual who is not saying what the behaviours are, to be specific about them so that it can be identified. And that in itself requires knowledge, you know, from a manager's perspective or HR's perspective, to be interested to differentiate between the two. But I think overall, I think regardless of whether it is harassment or bullying, the process won't work. So, you know, the disciplinary or the grievance procedure, just in my experience, or even the procedures within the harassment and the bullying policies, because they're the same, as you've said. So they often, with a bullying and harassment policy, the process is similar to a grievance.
Yeah.
It's just it's pretty much the same very often.
Yeah.
So it's the same process. Again, the aim is not really to support individuals to resolve the problem. And I think that's often perhaps where there's frustration for all involved, because we're all expecting this procedure to work.
Yeah.
And
Yeah.
And it just doesn't.
Yeah. We're handing over the resolution to the procedure, aren't we?
Yeah.
And then rather than saying, so what is it that I can do that will either support myself better in this situation or that can help me resolve it with this other person? No matter how much I hate them, I still have to work with them.
Yeah.
So therefore, and I want to keep my job, and I want there to be a productive outcome from my day at work. And I want there to be an improved relationship in this environment. So as I say, so this is the thing, I think quite often, you know, in terms of what mediation can, as we know, offer in this situation. And this is why, for me, I've got, in a sense, quite a thing about mediation, because I've seen so many, or a thing about bullying, rather. I've seen so many cases where bullying has been alleged, come through mediation and resolve.
Yeah.
Whereas the expectation was it was just going to be a division, an exit, people leaving, etc. And the reason, as you, I think, know from things I've said before, the reason is because we stopped talking about bullying. We talk about what's happened.
Yeah.
Well, they stopped.
They talk about bullying. Yeah.
Yeah. So, as you know, I would say to people, so what is it they do that you say is bullying? And even if they're not clear about how they vocalize it, like you said, there are always specific things that have happened or incidents that have led to them seeing it as bullying. And that can be discussed, and people can talk about, well, you know, when that thing happened in the office, and it's like, yeah, but, you know, you did this. Okay, so it's, instead of it being a kind of an evidence-based prove and punish approach, it's like, okay, so if that happened again for both of you, what would you want to happen differently? How would you want it to have been dealt with? What can mean that's possible? You know, what might mean that's difficult to do? What is it that you both see as a way forward in this situation? So it's always about that, instead of, well, have you got proof? And, you know, well, you know, why is it you think that's not an appropriate thing to do? And it's kind of, as you say, it's about trying to kind of come up with evidence, respond to allegations, prove who's right, prove who's wrong. There's no exploration of, well, should that happen again, what would you both want to do differently? Yeah. Or if it's in conflict coaching, if that happened again, what would you want to do differently? How might that be possible? How could you create that for yourself? And it's always about future focus and saying, shit happens, what can you do once it's happened and move forward? What can help you with that? So there's no, and none of that is about proving, if it's a discussion around bullying, none of that has any focus on proving bullying. It's always about being creative and supportive. And so much could then happen. I mean, as I say, the reason a lot of people who kind of, because, you know, I write online about it and I go on LinkedIn and people say, oh, you're being, you know, you're letting off the bully and all this kind of thing. And I kind of think, well, you know, you're coming from an experience where the bullying procedure didn't work for you. So what is it that you mean that saying more and more about this means it will work any better? It's about saying that it's about acknowledging you're never going to be able to prove that one person is a bully, because there just isn't the objectivity around the situation for that to be possible. But almost conversely to that, you have an opportunity for the situation to be improved. And as I say, this is then where some people say, no, I'm never going to sit in a room with them. And that's fine if they really feel that strongly, but they're still left with the same problem if that's the case. So what might they be able to do even if they don't want to go to a mediation with them, which is, you know, is where conflict coaching comes in. But it's always about supporting that person and creating a way forward for themselves. And
which is different, isn't it, from the disciplinary, from the grievance process, where you're handing over that the individual is disempowered. The person raising the complaint is completely disempowered, and the outcome is taken. So they're the ones who's experiencing the problem, experiencing the issue, and it's almost like handing it over to somebody else. So you sort it out.
Yeah.
But then okay, well, you sort it out. So the person is fired. Well, okay, does that really sort it out? Does it really resolve it? Well, maybe the person is not fired, or the finding is that no, Mel, you know, you weren't bullied, and I'm left disempowered and unhappy with the outcome, and I can appeal through the same process to potentially get the same outcome. And as human beings, it's just not the way we live either. You know, it's completely, you know, completely alien to the way that we live day to day, and how we, you know, we don't teach our children that, you know.
Interestingly, I think the thing is that in a sense there are ways in which it can be seen as being very parent-child, because you know, for me, the kind of metaphor that I see with a lot of those things is that someone runs to the parent and says, so-and-so did a bad thing, tell them off. And sometimes the parent does tell off, you know, the other one, and then they feel resentful. And then they then do something worse to the one who's got them told off. And it's kind of this silly, like, you know, and the parent doesn't have a clue what's going on because they don't see it. Whereas I know that there are, you know, and that's kind of a model which just doesn't work. But I do think sometimes it's a model that has come from people's experience into the workplace. Whereas,
I think it's replicated. I agree.
I do believe there are some parents who will actually say, well, you know, what are you both going to do about this? You know, I don't want you coming to me with these kinds of things. You know, I want you both to kind of be able to be nice to each other, or kind to each other, or considerate of each other. So how are you both going to do that? So that parent is then taking themselves out of making any judgment based on no knowledge whatsoever about what's actually happened, and placing it back with the children. So then they're treating them like adults. So it's an adult relationship. And yet, you know, what you've been saying and I've been saying about grievance procedures, bullying procedures, they're very parent-child in the run to the person, make a complaint, expect the other one to be told off, there to be then, you know, no, I didn't, yes, you did, no, I didn't, yes, you did. And the person's still thinking that they can make a judgment about who's right and who's wrong in the situation.
I think it's really, as well, it being disempowering, it's also, you know, that impacts on people mentally and psychologically. So whilst on the one hand, you know, I've experienced employees saying, well, what are you going to do about this? And it's passing of the responsibility, but it's also understandable that employees will do that because it's become the parent-child relationship. So it's, well, you're in charge. You say you're in charge. So if you're in charge, you do something about it. And so there's something to be said for bringing it back, or bringing it to, in the first place, a grown-up adult relationship where it is each individual, each party, each person has a responsibility to contribute towards resolving it, whatever that resolution looks like. If that resolution looks like a parting of the ways in the relationship, in the working relationship, okay. But the same way as a family, you know, it's not you're sacked, you know, or you've got to leave. You just can't do that. Yes, in an employment relationship, potentially it can be done, but actually it's really difficult when you've got that parent-child. So the business is the parent, and you've got two children, the employees, who've fallen out. Well, then you're in the situation where it's well, either you've both got to go or one of you goes. And how do we choose who goes?
Exactly. Yeah. And I mean, and particularly when you have situations like a complaint being made and one person is moved, or even both people are moved to a different part of the organisation, they're both thinking, well, why am I the one who's been moved? You know, because if it's the person accused in bullying who gets moved, it's like, but I didn't bully them. Why are you moving me? I feel like I'm being punished without being proven guilty. And if it's the other one, it's like, well, why am I being moved? They're the ones who bullied me. Why should I? Oh, see, it's a cover up, it's a whitewash. And you get all of that, and none of it works for the organisation or the person managing it.
No. And also cost, like to go back to where you started in terms of the cost, because often when clients have come to me and I'm thinking, okay, well, got an allegation and we've got the person who's, I think the allegation's being made against them. And the question will be to me, well, what do we do now?
Mm.
And I'm thinking, this is a really difficult situation, because do we suspend them both? Do we both say to them, you can both remain at home? This is all supposed to be confidential, although not very often people know what's going on, but there's still people's, sense of self-respect. So how are we going to work this in the meantime? And I suppose then the option of something else, the option of, you don't have to have this problem taken out of your hands, and actually we'd rather it wasn't taken out of your hands, because you're the one who's experiencing it. So if I'm the person making the complaint, it's me who's experiencing it, and I have a responsibility in that. I believe that individuals have a responsibility when they are experiencing it to really be part of trying to find a solution. And of course, yes, there are situations, there are times when the relationship's broken and the individuals will say, we just can't work together. And it does depend on what the behaviours are and what's happened. And I do, I'm not suggesting for 1 minute, there are some appalling behaviours that as human beings happen between each other. Things are said, things are done that shouldn't happen, that are unlawful. And I'm not looking to undermine that. But in terms of the process, looking at mediation as a way of resolving it doesn't mean that it doesn't mean that the other options are not still there all the time. Exactly. It can live alongside it.
Exactly. Sorry, go on.
No,
Sorry.
But also I think it's just the way as well. For me, what's important is the way that the issues are approached. So the allegation language and the proven and all of that language for the person who's accused, and it could be that they have done what's been alleged. It may well be, but you don't know until it's been investigated and until it's been discussed. And so actually looking at changing the language used and it being more of a grown-up approach of, look, you've said this, you said this, we want to get to the bottom of what's happened, but we may not, but shall we be forward? Shall we look forward? I mean, what are your thoughts, when you've got kind of serious allegations and mediation? What's kind of been your experience, positive experiences of mediation?
Well, I think, that distinction about seriousness or not, for me, this is the thing, and again, takes me back to the distinction between bullying and harassment. If there's been an allegation of violence, you don't offer mediation. Yeah. If there's been an allegation of theft, you don't offer mediation. If there's been an allegation of harassment and there's some way in which that has been evidenced, you don't offer mediation, because it's not something which should be which should have any risk of people being denied their statutory legal rights according to the law. Whereas where there isn't something like that, or someone might think they're being harassed, but they're not actually, there's nothing to suggest it, because people are so mixed up with bullying and harassment being the same. People sometimes say they're being harassed when it's not harassment. It's not discriminatory. It's just they don't get on. But the thing about, as I say, I can almost hear sometimes people may be listening on this and say, yeah, but people won't want mediation. Well, that's not a problem, because they can have conflict coaching. The whole point of conflict coaching is it developed out of the fact that sometimes people don't want to meet together at a particular point in time, which doesn't mean to say they won't in the future, but at a particular point in time. But if they're going to be taking responsibility for improving things, they're offered the support of one-to-one conflict coaching to help them look at, well, what's happened? What might improve things? How can things go forward? How did you feel about that? What would help you? Etc. Always about being constructive. So it acknowledges the voluntariness of mediation, but it doesn't mean to say that if they don't want mediation, there's nothing can be done. But also what it emphasizes is, as you said, that there's an expectation on people to take some level of responsibility for it if it's not broken any laws. because it's their workplace relationship. They can't just hand it over to their managers and say, they spoke to me in a way I don't like, I'm making a bullying claim, you investigate and prove them, etc. It's just not going to work. So therefore, and so in terms of, you were saying, what's my experience? I say, I can't honestly think of a situation where people have come to mediation with an allegation of bullying. And obviously bullying is one of the more polarized situations. Sometimes it's just, just something that's happened and people are having difficulty, but where there's been an allegation of bullying and it's been made formal and gone through either a dignity at work procedure or a claim or a grievance procedure or whatever other names might be associated, they can be a bit more entrenched and polarized, because people are sometimes thinking, well, I don't want to try mediation because I want them to be proven to be the bad person. But as I say, sometimes people go through them and then realize, well, actually, this isn't getting me to the place I thought I was going to get to. And they have mediation. And as I say, because the whole topic of bullying is gone within the first 10 to 15 minutes, there's a detailed discussion of what's happened in their interactions. And it's not about, well, is that bullying or isn't it bullying? Is that bullying, isn't it? Who cares? It's how did you feel about it? What happened? What do you want to be different? I don't want to come and stand behind me in the open plan room and say, you've done that wrong, you've done that wrong, you've done that wrong. Why, what's wrong with you? You've done that. I don't want them to do that. I want them to actually sit down next to me, or I want them to take me to their office and talk to me about it. Yeah. And so it's not so embarrassing and it's not so intimidating. Or I don't want them to I don't want you, because they get a chance in mediation, to say it to the person. Yeah. I don't want you to send these emails around criticizing me. If you want to criticize me, do it as a one-to-one email rather than a group email. These are the very much the kinds of things that came up in universities, which is probably the main area that I've worked in terms of doing workplace mediation. Is predominantly been universities, but also other public sector organizations. But the bulk, I would say, of my kind of recent experience in the last 10, 11 years has been working with universities where, people in all roles might have fallen out, whether academics or support staff or kind of, can't remember the phrase that they use for people who are not academic, but obviously important to the running of the university, but kind of administrative, but yeah, they have other roles as well. But it's the absence of the word bullying, which is the significant thing once the mediation gets rolling, because they stop talking about is it or isn't it bullying, and they talk about, when you did this, it pissed me off. Yeah. So I would rather you don't do it in the future. Well, I did it because, okay, so how are you both going to move forward with this? If it happens again, how are you going to deal with it? So it's a very frank and open discussion. And, again, people say, yeah, but you can't say that to your boss. Yes, you bloody well can. You can sit in the room and tell them how you felt about what they did. It's a without prejudice forum. And so long as you don't slag people off and turn up and expecting to be able to abuse the other person, and you want to say, actually, I got really pissed off when you did that, you can say that because that's how you felt. Yeah. And you can have that kind of discussion. And I think people will often think that they're not able to do that. But for me, if I'm sitting in a room with two people, I'm sitting in a room with two people. I'm not sitting in the room with the boss and the employee. I'm sitting in a room with two people who've got a relationship difficulty. Yeah. I mean, it's probably not the right word for it, but I don't care what status either person has. Yeah. I'm there for them to be able to have a full and frank discussion, so long as they're committed to using the process to try to resolve things and take responsibility for that. And I think, what is often not recognized is that opportunity is there in mediation, that often people feel quite frightened by the idea. And it has to be said, there are some mediation practices which feed into that fear, particularly if you've got mediators who agree with the idea of compulsory mediation. Because if they've got that mindset, they're bringing that mindset into the room when they provide it. So they're not acknowledging people's fears and concerns, and that they have a right at any time to walk out of that room. if they want to. But when you've got that opportunity for an open discussion, it's entirely possible to learn more about that other person, to see their vulnerabilities, to see that perhaps they actually didn't mean to be as they were towards me. Perhaps they were having a bad day, or who knows what those things are. And I hear sometimes these things about, oh, but what about power imbalances? As if, simply because someone's a boss, they've got more power, as if they can click their hand and the person will be sacked. Bosses don't have that kind of power. And so, of course, but what a lot of people don't recognize is that some bosses are scared to death. I was going to say another word, but I shouldn't. They're scared to death of the employee who is in front of them, who they can't find a way of managing.
They're scared of saying something wrong. Often, often it can be that it all is about the non-communication because of fears or concerns or worries. I'm often I have clients who contact me and say, we just don't know what to say in the meeting. What should we say in the meeting? Because we're really worried we'll say something wrong. And that's a shame in the world we live in at the moment, and the world we've lived in for a long time now, is fear. Fear about if I say something wrong, and what will happen and what will be the consequences of that. And mediation, as you said, of course it's not a place, there are ground rules in terms of not being abusive to one another, in how we speak or act to one another, but actually being able to have a space which is confidential, where in terms of confidentiality, it's up to the individuals where it goes from there, but for them to agree the level of confidentiality. For us, we're not discussing it anywhere else as the mediator. For them to express how they feel in a way that is not covered by the disciplinary grievance procedures do not cover those. And the future focus, because often in my experience, individuals who raise grievances have often delayed raising it because they don't want to go through the process. They get to a point very often where they say, I just don't know what to do. And sometimes people leave because they would rather not, they can't cope with or find a way to deal with what's going on at work. They're fearful of the process because they know it's not going to resolve the issue, and they don't know what else to do. And I also advise individuals, and often they'll, what can I do? And I'll go, well, legally you can do these things, but then I'll often say, well, actually, aside from that, there are these other avenues that you can explore, including conflict coaching, which doesn't even have to involve work, where you can have a discussion with a conflict coach, not me in that context because I'm advising them, but to really consider how might they want to go forward with this, and explore what it might look like if they were to resign and walk away. What might it look like if they were to remain? What might it look like if they weren't going to address it? How could they address it? What are those options and opportunities? And just having the opportunity to sit with somebody outside of it as a conflict coach. And wouldn't it be great if businesses could, even if it's training up, and I know you do, training, but training up people within the organisation to be those conflict coaches. Or at least having access. We have employee assistance programs, which are rarely used. That phone number, you can get some counselling, but actually having somebody you can talk to and say, I really don't know what to do here. But they're not going to advise you. They're just
they're going to help you with what you can do. They're not going to say go here, go there, sign you. They're going to say, what can you do? What do you need? What's been the problem? How might you deal with it differently? What communication can you have? Because you, as you were saying, the reason that sometimes people leave is because they're either given, it's like an ultimatum, isn't it? It's like, well, take out a grievance procedure or shut up. And that's it. That's all they've got. So they can be sit there festering with the difficulty, but knowing that a grievance procedure isn't going to provide anything for them, and they don't really want to do it anyway. But it's almost like that's their only option. So they either choose to do that or they leave, and that's not good for any organisation either, is it?
Also, what I've also come across is that many employees in that situation may end up saying in a grievance, or that when they leave, or in tribunal, they didn't support me. They said they would support me, but they didn't support me. They just said all I could do was raise a grievance.
Yeah. And that's your support.
Yeah, that is your support. So the support is either shut up, learn to live with it, deal with it, ignore it, put up or shut up, or put up or shut up, isn't it?
Yeah.
Raise the grievance. And I'm not criticising managers or HR, because unless there is an alternative viable option that businesses are aware of and that is there as that viable option, then HR or managers are not going to know how else to support, because there is no other mechanism. And mediation is one option, as well as the conflict coaching, which I think, from my perspective, there is so much more, Alan, that that offers, that many businesses and many individuals are not aware of that.
And also just for managers themselves to learn skills which are supportive of that, because a lot of managers I know will, someone will come to them and they just won't know what to do with it. It's not in their job description. No. They've got to meet these targets on the project. They've got to do this, that, and the other. When two people come to them with a conflict, they haven't a clue how to respond, because they've never had any training. They've never, some will anyway, just naturally be quite good at it. But others will just be like, what the heck do I do here? I'll pass it to the HR department and the grievance. And, but in a sense, because it gets passed to HR, it then has to be treated formally.
Yeah.
So they don't have a capacity for dealing with it informally, which helps it to go away. Not go away, but I mean, helps it to be resolved through supportive kind of interactions with the people who bring the problem. So there's, even if people don't use mediation or conflict coaching, although as you say, I think conflict coaching has so much space for application and growth in these areas, because it means that people won't default to saying, oh, well, they don't want mediation, so that's it. Well, conflict coaching is there. Or in many approaches to mediation, some, particularly our approach to mediation, it doesn't have to mean that there's a joint meeting, because the initial meeting is supportive of ways forward in itself. So, but as you say, if there isn't even that alternative, then it is put up, shut up, leave, fester, or go down the formal route, which isn't going to help you anyway. So,
which is often what HR will know as well, and they will know that. Most, individuals who mean well will know that when they say, and I've advised people, I said, you can go down the grievance route, but the aim of the grievance, or the way that the grievance outcome is likely to be, is going to be somebody else is going to make the decision on this, and you might find that what you've said is not agreed with. And how do you, and I'll often ask that open question, how do you feel about that if that's the outcome that you're going to face? And having the alternative, but it's also, currently in the workplace, many of us are wanting to work in places where we're valued and respected, where we spend so much time, but the expectations have changed from employees, or the workforce as a whole, because of course there's employees, there's freelancers, there's a raft of different ways of working, self-employed contractors, workers. The expectations of what individuals want from their work, what they expect and how they expect to be treated, and mental health. We used to talk about health and safety, and it was really, making sure a ladder doesn't fall, I don't fall off a ladder, or something doesn't fall on my head. and actually the Health and Safety at Work Act is actually about welfare as well, and mental health. And now mental health is probably bigger than physical health. And most grievances that I come across will have a stress element to it from both sides. So the person who ends up being, I'll rephrase that. So the person who is alleged to have done something wrong will frequently suffer from stress as a result of that.
Absolutely.
Which is understandable.
Yeah.
And the person making the allegation may well experience stress because of what's happening or they say is happening, but both will then experience stress from the process itself. And as somebody who has also done grievances and managed them and been a grievance, decision maker, the process, not the process itself, but the complex nature of fallout and conflict can also be incredibly stressful for the person who's got to make this decision.
Exactly.
And it's just tears in my view, it's stressing everybody out.
Yeah.
And how on earth can a business then support the mental health and well-being of all of its employees?
Exactly.
When this process, it is not aimed to support that.
No.
So actually, let's look for something else, or let's have something that aligns, if it's possible to align with it. I don't know that it's possible, but it is what the law is, and it must be, as procedures are there for a reason.
Yeah.
But at least is looking after people's mental health. And considers that. And so, that does require a radical overhaul, in my view. It requires ripping it up to some extent and going, we'll have a meeting with you and we'll discuss what's happened. But the approach can be done in a way that still uses the principles of mediation and the principles of certainly CC.
And the thing, I wouldn't, obviously there might be things that I don't know about or understand, but for me, it doesn't have to be that radical a change, because all that needs to be available is mediation, conflict coaching in parallel, because then people will choose. They have a choice then. That put up and shut up isn't the case anymore. It's like, you can try this one or you can try this one, and both are available to you. You have a right to choose the adversarial process. You have every right under law to be covered with that. This is what it is. This is what's available. But you also have this option, whether it's mediation or conflict coaching, in parallel throughout the life of any complaint that you make, that is there for you. And you have a choice. You have power because you have a choice. And you can even try both.
Or all three.
Yeah, exactly. And this is the thing, that it's only the not having a choice, which is so difficult for people. They have to do a grievance procedure or they have to shut up. And that's not a choice. It's like there is no availability of service to them there to support themselves and for them to support themselves in their situation. Whereas continuous availability of mediation, conflict, it's not hard to do. There's nothing difficult about that, is there? Because some people might say, but where does mediation go in? It doesn't go in it. It's separate to it. It's entirely alternatively available at any time for any reason for people to use if they're feeling that there's a difficulty in the workplace. But so often it's made much more complex than it needs to be by saying, should it come after local resolution or should it come after? It doesn't have to come after any of those stages. It's nothing to do with those stages. They can carry on as they wish to.
It should just be there, shouldn't it? It's there.
Exactly.
I think the conflict coaching part, if that were available to businesses, and if that was available kind of within businesses and a natural something that businesses were aware of, that employees were aware of, a bit like everybody knows you can raise a grievance. Actually, if we were to be able to get to that point where everybody knows you can, there's the option of
a conflict
coach, and there's the option of mediation. And as you said earlier, I just want to pick up on that point about the CC mediation process, it doesn't necessarily result in that joint meeting.
Yeah.
Traditionally, mediation is considered to be this joint meeting, and of course, as you and I know, the process does not have to run that way, and actually the CC process does not run that way. The chaos model doesn't run that way. It runs so that individuals are asked separately whether or not the initial point is the person who has the complaint or has the concern, who has raised it, is asked, do you want to consider mediation, yes or no? Have an initial meeting, and in that meeting itself, as you and I know, it is an opportunity to explore resolution. So the conflict coaching skills are used, and the individual experiences the opportunity to come up with a resolution, which might be that at the end of it they say, do you know what? No, I don't want to have a joint meeting.
Exactly. I
don't need it.
Unfortunately, a lot of approaches to mediation don't take advantage of that opportunity in the initial meeting. They see the initial meeting as being sometimes a quick half-hour meeting where it's just, do you want a joint meeting or don't you?
Yeah.
And it becomes like a double glazing sales approach, trying to sell a joint meeting instead of just helping people to think through whether they want one or not, and even if they don't want one, what might still be possible. So it depends on the approach that the mediator is using. If they're absolutely grimly determined to get people to go to a joint meeting when they don't want one, they'll be very disappointed. But if they're using that initial meeting as an opportunity to explore with people, as you've just said, what might still be possible, even if there's not. And some people might say themselves, do you know what? I don't feel I need a joint meeting now. I could do these things that I've been considering with you in this initial mediation meeting. Then, hopefully most organisations would say, well, that sounds all right, because we don't have to pay for a joint meeting as well as an initial meeting. Yeah,
and having the opportunity, even for the conflict coaching, if that was available, for HR teams, I'm talking about in an ideal world here, wouldn't it be great if, rather than every time somebody's approaching HR, it's because there's a problem, it's actually HR gets the opportunity to be forward thinking and to be progressive, rather than always dealing with the problems or the problems coming to HR or the managers, so that the problems are not seen as being somebody else's, or the individual has a place to start resolving it.
To be initially genuinely supported.
Yeah,
like you said earlier, some people say, well, I was supposed to be supported, but I wasn't supported.
Yeah, and being able to say, absolutely, we have some support here. This is who you can go and talk to. You don't need to say any more to me unless you really want to.
Yeah.
And you know where I am if you if you want to take this any further.
Yeah, exactly.
And that is empowering, having that place of support, rather than go and read the handbook and see what's in there.
Yeah, exactly. I have to note we've run over our time. Well, not run over, we've taken the perfect amount of time, because now would obviously have to be the time that we stop. So
yes.
So fantastic. Thanks for that, Mel. What I'll do, I'll draw this to a close, and I'll put it out to people on the podcast and the video. We'll see what comments, if any, people make. And I would be very open, if you would be as well in the future, to having other discussions on similar or related topics. For now, we'll bring it to a close. I'll say goodbye to everybody who's been watching, and thanks very much for listening.
Thank you everybody for listening.
And I'll see you again soon, Mel.
I'll see you again soon.
Cheers, Mel. Have a
Bye.
good. Cheers.